Good afternoon. As Brittany said, my name is Heather Tenney, and I'm a partner here at Tully Rinckey, where I practice federal employment, military, national security, and veterans rights law. And in the last few months, I've been spending a great deal of time speaking with federal employees concerned about reductions in force, or as we'll refer throughout this, RIFs. And that's what brings me here to speak with you today. I will say, though, RIFs, it's a dense topic, and by no means can this be an exhaustive presentation. The purpose is to give you an overview of the process for many federal employees and familiarize you with some of the terms and overarching issues. But some of the topics in this area could be their own webinar, which hopefully we will be presenting soon, and you will attend those as well. Prior to today's webinar, we received some great questions, and answers to many of them will be given throughout the presentation, but regrettably, we're not going to be able to address all of them, as many are very specific and would probably be addressed better in an individual consultation, or are potentially like more offshoots of other issues like retirements, benefits, which we hope to have separate webinars on soon. So what is a RIF? Ultimately, it's the term that federal agencies use for purposes of, calling it layoffs, downsizing. An agency has to use RIF regulations before separating or demoting an employee because of an organizational reason, such as reorganization, lack of work, shortage of funds, insufficient personnel ceiling, or exercise of certain reemployment or restoration rights. In fact, virtually all RIF actions are a result of reorganization. The agency is reorganizing as a result of a shortage of funds, lack of work, restructuring. A furlough can also be a RIF, or at least have to use RIF procedures, and a furlough of more than 30 calendar days or of more than 22 discontinuous work days, again, would be considered a RIF action. However, a furlough of 30 or fewer calendar days or of 22 or fewer discontinuous work days, it would be considered more of an adverse action, which has a whole separate and different process associated with it. Like I said, ultimately, RIF actions, are going to focus, and what we're going to focus primarily is on the idea of probably more separations and downgrades as opposed to a furlough, in part because of what's going on right now. Now, the agency has a lot of discretion and autonomy to determine if a RIF is necessary, and the number and types of positions needed to be abolished, and the timing of when a RIF occurs. When an agency eliminates positions, the RIF regulations, which are contained at Title 5, Part 351 of the Code of Federal Regulations, they're going to determine whether an employee keeps their present position or whether the employee has the right to a different position. The Office of Personnel Management has been responsible for issuing guidance for agencies on RIF procedures. They actually are a relatively good source. In fact, there is a handbook called the Workforce Reshaping Operations Handbook that can provide very detailed guidance on RIF processes, which is a good idea and a good reference point. So if there are things that are brought up here today that you have, more questions about that wouldn't necessarily be best covered in like a consultation, you may want to use that as a resource. Now, unless it's excluded by a statute, RIF regulations apply to each federal civilian employee in the executive branch and any position that is subject by statute to competitive service requirements or is determined by an appropriate legislative or judicial administrative body to be covered by the retention regulations. However, there are some employees who aren't covered. Some specific, and we're talking about covered under the Title 5, Part 351 of the Code of Federal Regulations. Some examples of employees not covered under those RIF regulations are members of the senior executive service, who we're going to speak about in greater detail in a little bit, Also employees whose appointments are confirmed by Congress, non-appropriated funds employees, and some other employees may have modified RIF regulations, like administrative law judges. They're covered on under 5 CFR Part 950, and some USPS postal employees with veterans preference. Now, just because a position is being abolished or an agency is trying to reorganize, that does not always require the use of RIF procedures. The agency has the right to avoid a RIF action by reassigning an employee to a vacant position in the same grade or pay without regard to the employee's rights under RIF regulations. The vacant position may be in the same or a different classification series, line of work, or even geographical location. There are many tools available to avoid a RIF, but when separating, involuntarily demoting, or furloughing an employee for more than 30 calendar days or of more than 22 discontinuous work days, the RIF regulations are going to apply. Now, ultimately, the legal basis for RIF regulations, as I mentioned a little bit, it actually derives from a couple different areas. The first is Section 12 of the Veterans Preference Act of 1944 and other statutes. These laws are codified then in sections 3501 through 3503 of Title V of the U.S. Code. And OPM implements these regulations through regulations published again through Title V of the Code of Regulations at Part 351. Now, RIF regulations have to give effect to 4 different retention factors. The retention factors are tenure of employment, and that's generally going to be like type of employment. So are we talking about, competitive, accepted service, etc. Veterans preference, total credible civilian, federal civilian and uniform service, and performance ratings. The retention register is ultimately the ranking of employees in the competitive level after each agency applies the 4 retention factors. We'll discuss all of this in more detail throughout the presentation. So in order to prepare for a RIF, the agency needs to make 3 key definitions. Those definitions are local commuting area, competitive levels. I'm going to start with competitive area because it has a significant interplay with commuting area. So competitive area are the boundaries within which employees compete for retention under the RIF regulations. Basically, it establishes the geographical and/or organizational limits for RIF competition. And it includes all employees within the organizational unit and geographical locations that are included in the competitive area. It may consist of all or part of an agency. The minimum competitive area is an organization in the local commuting area that it's going to be separate from other agencies' organizations because of differences in operation, work function, staff, and personnel administration. Now, this is important, this idea of separate personnel administration. That is the authority of managers to authorize personnel actions like abolishing positions, establishing positions, not just process personnel actions. And as I said, this is an important issue in the current RIFs, as we have been seeing many of the RIF notifications that have come in seem to drastically and narrowly limit the competitive area as to really prevent any ranking to actually occur, because the entire competitive area is then deemed to be, being removed or abolished or otherwise discontinued. Now, the regulations do not define a maximum size of a competitive area. Employees in a competitive area compete for retention under the RIF regulations only with other employees in the same competitive area. Employees do not compete for retention with employees of the agency who are in different competitive areas. The local commuting area is, again, the geographical area that usually includes one area for employment purposes as determined by the agency. The local commuting area includes any population center or 2 or more neighboring centers, and the surrounding localities in which people live and can reasonably be expected to travel back and forth every day to their usual employment. Each agency has the right and responsibility to define the local commuting areas and establish this definition. OPM has not actually established a mileage standard to determine when two local duty stations would be included in the same local commuting area. Now, as I said before, there is an interplay between commuting area and competitive area. When an organization has components in more than one local commuting area, the agency may designate each local commuting area as a separate competitive area. When two or more different organizations of the same agency are located in the same commuting area, to determine a minimum competitive area, the agency should refer to its controlling documentation to determine whether the organizations are under separate administration. Now, competitive level. Competitive level, after you establish the competitive area, the agency then establishes the competitive level that includes groups of interchangeable positions. When an agency applies the 4 RIF retention factors, tenure, veterans preference, length of service, and performance ratings to the competitive level becomes the retention register, which lists employees in order of their relative retention standing. Now, positions within one competitive level generally are going to share the same grade, series, and official tour of duty. So like full-time, part-time. These positions also share interchangeable qualifications, duties, and responsibilities based on the position descriptions, not the actual experience and expertise of the individuals holding such positions. Now, 2 positions can be safely placed in the same competitive level when the position descriptions for the 2 positions show that the employee in either one of those positions needs no more than 90 days to be able to perform the key tasks of the other position. And again, the agency establishes this based on the employee's official position of record, position classification, series, and or grade on the effective date of the RIF. The agency may not place positions in a competitive level on the basis of personal qualifications or performance levels of individual employees. Each competitive level is ultimately, again, going to share, positions with the same grade, classification series, or tour of duty. And ultimately, like I said before, the retention register ultimately is going to be the application of these things then, and when you apply that to that competitive level. And the retention register lists all competing employees in the order of their relative retention standing in a single competitive level. The retention register includes the name of each competing employee who holds an official position in the competitive level and is serving in that position, is temporarily promoted from the competitive level by either temporary promotion or term promotion, or is detailed from the competitive level under Section 3341 of Title V of the U.S. Code or other authority. Some employees are listed apart. It does not include every employee. For example, the retention register does not include the name of a competing employee on military duty with a restoration right to the competitive level. The employee does not compete for retention under RIF regulations. Instead, the employee has restoration right based on their military service. Certain other employees may hold positions in a competitive level that don't compete, like term appointments or term promotions. So the process to determine retention standing, as I said before, ultimately there's these 4 retention factors. The first being tenure. Employees are going to be ranked into one of 3 groups. And then the statutory retention factors are implemented according and following the order of the retention register. So tenure, there are, again, three groups. Group one is career employees who are not serving probation. This group also includes managers or supervisors who are on a probationary period required upon promotion to that position. Group two are employees who are probationary due to a new appointment, as well as career conditional employees. Group three are employees who are under term or have a comparable non-appointment status. So factor two is veterans' preference. Once an employee is sorted into group one, group two, or group three, they are then sorted into a subgroup based on entitlement to veterans' preference. So subgroup AD includes veterans who are eligible for RIF preference due to a service-connected disability of 30% or more. Subgroup A includes veterans eligible for RIF preference who are not eligible for subgroup AD, including eligible spouses, widowers and widows, and mothers of veterans. We'll talk a little bit about that in a second. That's what we call derivative preference. And subgroup B, which includes non-veterans and others who are not eligible for RIF preference under subgroups AD or A. Now, this is probably something that people sometimes don't understand, and it's not something that's intuitive. A retired member of the armed forces is a veteran under RIF regulations if and only if the armed forces retirement is directly based on a combat-induced disability or injury, or the armed forces retirement is based on less than 20 years of active duty, or the employee has been working for the government since November 30th, 1964 without a break in service of more than 30 days. So again, in terms of the kind of issue related to that is most people would expect, oh, this is a retired service member, so obviously they have veterans preference. But again, a regular retiree is not necessarily going to have RIF regulation preferences. So just be aware that that might be an issue, but also be aware that that could be an error that's being made by the analysis. So it's always good to have, a full review of the records to make sure that you're being properly classified. Now, I did want to talk again a little bit about when we were talking about subgroup A, this idea of what we call derivative preference. That extends the types of employees that are listed to get the preference, and this can be an unmarried widow or widower of a veteran, and as defined by section 2108, Title V of the U.S. Code. It includes a spouse of a service-connected disabled veteran, and disabled veteran is defined again under that 2108 of Title V of the U.S. Code, who has been unable to qualify for a federal position. Now that's an interesting point, because I actually talked to somebody a few days ago who was trying to address whether or not they would be eligible for a derivative preference. And their spouse does not work for the federal government, but they are not necessarily unable to qualify. They had retired, but not medically retired. So in that instance, they would likely not meet that requirement, even though their spouse is a disabled veteran. Their spouse would be able to qualify for a federal position, even though they are not in one, and even though they have the disability. A mother of a veteran who died in a war or campaign, provided that the mother also meets the other statutory conditions covered in section 2108 of Title V of the U.S. Code. Also, the mother of a permanently disabled veteran, provided the mother also meets the statutory conditions covered in another section of that. So again, there can be both kind of caregiver roles, or the mother of a deceased veteran can ultimately derive this as long as they meet those criteria. So retention factor 3 is length of service. So ultimately, employees are ranked within the subgroups based on the respective service states. Retention credit, you receive credit for all civilian service performed as a federal employee that meets the definition of employee in section 2105 of Title V of the U.S. Code. Civilian service that does not meet the definition in 2105 can count if the controlling statute specifically defines the service as credible under RIF regulations. All active duty performed in uniform service except as restricted by law for certain members of the armed forces who are receiving retired pay. And that gets into, again, retired member of the armed forces with 20 or more years of military service who is not eligible for veterans preference under RIF regulations receives retention credit only for armed forces service during a war or service performed in a campaign or expedition for which the individual received a badge. An employee may not receive dual retention service credit for service performed on active duty that was performed during concurrent employment as a federal civilian. So performance ratings are criteria, retention factor 4. Extra retention service credit can be issued based on employees' performance reviews. An agency uses the average of the last 3 annual performance ratings of record from the 4-year period prior to the issuance of the agency's RIF notice. Now, ultimately, the RIF regulations cover situations where all employees in a competitive area are covered either by the same rating pattern or by more than one rating pattern. This can get a little complicated in terms of how, but in general, employees can receive anywhere from 12 to 20 additional years of service credit based on their evaluations. If ultimately they have, 3 outstanding, the equivalent of when we use like a 5-tier 5s, then they're going to get the max of 20 years. And obviously thereafter, there can be variation. Ultimately, again, if there are fewer, as I said, there are approaches that are taken. So if the employee has fewer than 3 ratings in the 4-year period, there's 2 different approaches that can be used. But the long and short of this is I've actually seen many notifications that this is a concern because people are not receiving the proper classification of what their evaluation score should have been. So this is something that you would obviously, if you notice that you were being, it said that you had 3 3s or a 5 and a 3 and a 4, you may very well want to, that's something that you're going to want to correct, because that does have a bearing, because it ultimately adds additional retention service credit to your overall service computation. Now, in terms of the actual process, after all of those definitions have been made and people have been properly classified, when the agency is going to, then there's 2 rounds. The first round, the agency is going to apply all those 4 factors that we just talked about to ultimately glean the ranking of the employees, the lowest of which may be released by the RIF. The second round, the agency applies the 4 factors again, determining whether the released employee has any bump or retreat right to a position in a different competitive level that is held by an employee with an even lower retention standing. Now, it's important to know that the agency must release all employees within a subgroup before moving up to the next subgroup. So, for an example, you have to release all the subgroup B employees before releasing any of the subgroup A employees. Similarly, the agency must release all employees in a group prior to moving up to the next group. So if ultimately an agency is going to have to release all the employees in group 3 before they move to group 2. Now, ultimately, a released competitive service employee in tenures group 1 or 2 has bump or retreat rights to an available position in the same competitive area if the agency would otherwise separate or demote the released employee by RIF. And the released employee has a current performance rating of record equivalent to minimally successful or the equivalent or higher. Now, as you can see, there's a list of what ultimately is an available position. You know, this is not going to be a position that is a temporary. At least it's got to last for, 3 months. It's got to be in the competitive service. It's got to be something that the released employee would qualify for. It has to have a pay rate that requires no reduction or the least possible reduction in the released employee's present grade, but not a position that's in a higher grade than the position that the employee currently has. One with the same type of work schedule. You're not going to then move somebody to a position that's like if you were full-time to a part-time. It has to be within 3 grades or grade intervals of the employee's present position. And ultimately, it has to be held by an employee in a lower retention subgroup who is subject to bump rights, or in the same subgroup, but with less service, who holds a position which the employer formerly occupied on a permanent basis, or essentially the same, like an identical position that is subject to what we call retreat rights. So again, bumping is displacing an employee on a different competitive level in a lower tenure group or subgroup. Retreating is displacing an employee on a different competitive level with less service within the released employee's own tenure group and subgroup. An employee with a current annual performance rating of record of minimally successful or the equivalent has retreat rights only to positions held by an employee with the same or a lower performance rating of record. For both bumping and retreating, the new position must be at the same grade or within 3 grades or grade intervals of the employee's present position. However, there are exceptions. If the released employee is a disabled veteran in subgroup AD, at which point the position may be up to 5 grade or grade intervals lower than the position held by the released employee. Employees with unsuccessful ratings have no rights of reassignment to other positions. Further, accepted service employees do not have bump or retreat rights. So I want to take a little divergent path because many of the people we talk to fall into the category of being members of the senior executive service. And they have different procedures, as we talked about before. Ultimately, an agency must issue and provide OPM written SES RIF procedures before implementing any reduction in force affecting career SES members. These procedures have to be based on performance as established in the final annual summary rating, not any interim rating per the Code of Federal Regulations, and they're not based on veterans' preference per the U.S. Code. Competitive areas for SES RIFs are much broader and often encompass the entire agency or a few major components. SES RIF procedures develop competitive levels and retention registers, but they should not be broad as the use of unnecessarily large groups, which any employee can be chosen for release, may subject the agency to actions to challenge the action as being what they call arbitrary and capricious. So the agency's SES RIF procedures have to ensure several other things. A non-probationary career SES who is identified for removal is entitled to be assigned to any vacant SES position in the executive agency for which they are qualified. The agency head may certify a non-probationary career appointee for OPM placement assistance only if there is no vacant SES position in the agency for which they qualify. Competitive procedures apply to probationary career appointees as well. However, a non-probationary career appointee must be retained over a probationer with the same retention standing. A non-probationary career appointee identified for RIF is entitled to a vacant SES position before a probationer identified for RIF may be assigned to it. and a probationer identified for RIF is not entitled to an agency SES vacancy or to an OPM placement or to OPM placement assistance, and may be removed under the CFR with 1 day notice. A non-probationary career appointee identified for removal by an SES RIF will receive specific written notice at least 45 days before removal, and a second notice 1 day before removal. A career appointee, whether they're probationary or a non-probationer, removed by the RIF procedures, has a guaranteed placement in a non-SES position at GS 15 or above, which would generally talk about like senior leader positions. Ultimately, OPM is going to provide priority placement assistance to career SES members who successfully completed the SES probationary period and who, but for placement rights afforded under the U.S. Code, would be removed from the SES because of a RIF within an agency. Eligible SES members are entitled to priority placement assistance from OPM for a period of 45 calendar days. OPM 45 calendar day period begins when OPM acknowledges the agency head certification, and a non-probationary career SES appointee must apply to OPM to initiate the assistance. The agency may remove the career appointee by SES RIF upon expiration of the agency notice period only after OPM advises that the career appointee has declined a reasonable placement offer, or OPM advises that the 45-day period has expired without placement. Per the CFR, if an agency is being abolished without transfer of functions and its SES members are being separated at the same time or within 3 months of the abolishment, it's not necessary to use the competitive procedures. So we talked about all these things that the agency is supposed to do or how these processes are supposed to work, but particularly right now, there may be some issues as to how they were done. So there are rights to appeal. So per the CFR, any competitive employee adversely affected by a RIF has the right to appeal to the MSPB. Specifically though, we're talking about an employee separated, downgraded, or furloughed by RIF for more than 30 days, may appeal to the MSPB. The appeal must be filed 30 days from the effective date of the RIF action, not 30 days from the notice, 30 days from the effective date. Now, in terms of burden of proof, the allocation is treated as though the RIF were an adverse action, which is not actually the case because these are not based on performance or conduct. But since RIFs are technically directed at the position and not the employee, that's why they're not considered adverse, although they have, to the employee adverse consequences. Now, where there is a negotiated grievance procedure, and if that the negotiated grievance procedure must be used, then, the bargaining unit would then do that. However, if as part of the appeal, the argument is that there is discrimination involved, that action is appealable to the MSPB or through EEO. Now, again, in terms of burden of proof, the agency is going to have the initial burden of proof that it conducted a proper RIF. An agency is going to meet its initial burden by making a prima facie showing that it conducted a RIF for any of the reasons that are articulated in 5 CFR 351.201 alpha, which we talked about before: lack of work, shortage of funds, insufficient personnel ceiling, reorganization, exercise of reemployment rights or restoration rights, reclassification to a position. Now, if the agency establishes that initial burden, once they present the evidence establishing the RIF action, the appellant then has the burden to prove by clear and convincing evidence the impropriety of the agency's procedures and specify the basis for the allegations of error in the RIF process. Now, some of the most common challenges are going to be failure to provide an adequate notice. The CFR ultimately provides that employees are entitled to specific written notice of at least 60 full days before the effective date of the release. There are some opportunities for a reduction in that time, but they're usually going to, number one, have to be authorized by OPM, and they're going to have to be for specific need. But if you did fall under those and do not believe that would be something potentially to challenge, or that there are issues with the actual notice itself, failure to place an employee in the correct competitive area. This is probably something that I think many people will be complaining about with some of the current RIFs that are going on. The agency must prove that the competitive area is separately organized and clearly distinguished from others in operation, work function, staff, and personnel management, and where the head of the subdivision has the authority to take personnel actions, not just process them. Failure to place the employee in the correct competitive level is another area. The agency is going to bear the burden here by a preponderance that the competitive level was properly drawn by showing that the appellant's qualifications required by the duties and responsibilities of the description were substantially similar to other employees within the same competitive level and were different than employees in other competitive levels. Sometimes here there can, even though again we talked about early with competitive levels that the position is based on what is your actual position description, there have been situations where the courts have, or the MSPB has viewed like the actual positions that and duties that the person is actually performing in some of these types of challenges. That if on paper your duties were one thing, but in reality they were others, it could have an argument that you were not placed in the correct competitive level, even though ultimately the competitive level is supposed to be drawn by virtue of what your actual position description is. Challenge to the retention standing is obviously an issue that one can appeal when an agency discovers an error in determination of the retention standing. The CFR requires that the agency correct the error and adjust any erroneous RIF action. Now, obviously, if they don't find that, and that's something that's discovered by the employee or as part of the process of appeal, that obviously is a basis for challenge. Now, the board, the MSPB, ordinarily is going to lack jurisdiction to review an employee's voluntary reassignment taken to avoid consequences of a RIF. A voluntary reassignment accepted by an employee to avoid the consequences of an impending RIF is generally considered not appealable. However, the more closely that the reassignment process is resembling the execution of a RIF, the more likely the reassignments will be considered part of and contestable as a RIF. And there's cases, for example, this case, Price versus Department of Transportation, by the time the employee was reassigned, the RIF was effective and the employee had served the entire notice period. Additionally, the board lacks jurisdiction over a transfer to another agency done after RIF notice is made unless the evidence suggests that the transfer was involuntary. An employee may appeal a RIF if he or they receive a notice that they will be separated through a RIF, and before separation, they apply for and accept a lower graded position in another competitive area, through the agency's voluntary placement program. An employee may appeal when their priority placements rights have also been violated. So what are the things that you would be seeking if you were appealing a RIF? Well, generally, you're seeking to be reinstated, you're seeking back pay, you're seeking attorney's fees, and any other relief that you may be entitled to. And what that relief could be, may ultimately be impacted by what you're alleging the issue to be, especially if it involves things like affirmative defenses. Like, was this motivated by discrimination? Was there some other unlawful purpose that created some sort of, harm? So in terms of everything that's going on right now, one of the big concerns is with all these RIF actions, as you see, we're talking about appeals to the Merit Systems Protection Board. And right now the MSPB, while you can still file appeals for initial decisions, and for initial decisions rendered by administrative judges, there is no quorum, which means that if ultimately a case, either you as the appellant were trying to appeal the initial decision by the administrative judge, or the agency was going to, generally the next step is to do a petition for review to the MSPB Appeals Board, that three-member body there where there is no quorum. So that could lead to some significant delays in relief until that gets worked out. Another big issue that obviously is going on right now, and I did see many questions in the webinar questions sent by our attendees today, is about the litigation that's going on right now involving these different RIFs. Now, there's sort of two different kind of big areas. There were the original issues associated with people who were removed as probationary employees. Those were not done specifically as RIF actions, but by virtue of some of the challenges that have been made, they are being viewed as what we would call a constructive RIF. And there has been, the MSPB recently did certify a class of employees arguing that the probationary terminations were in constructive RIFs. We have not had decisions yet. Now, some of the litigation on those issues, originally there were some preliminary injunctions that had been issued, some temporary restraining orders. However, one of the primary preliminary injunctions involving the probationary terminations was ultimately lifted by the Supreme Court. They did not continue the preliminary injunction while the cases are being appealed. Now, the kind of more maybe relevant to a lot of the RIFs that are going on now, not the probationary termination and the constructive RIF, but the RIF notices that have actually been issued as RIFs. There have been a few different cases, probably most notably a case in the Northern District of California that 2 Thursdays ago issued an injunction. And ultimately right now, many agencies, I think 19 in total, are enjoined from completing their RIF process. Many different issues raised in that, in part, a lot of it regarding some of the things we've talked about, also some questions of whether or not there are even potentially constitutional issues of the orders exceeding authority and eliminating, it's basically an impermissible expansion of presidential power. Now, the preliminary injunction is not a finding of illegality. It is ultimately still to be adjudicated on what we would call the merits. But right now, that injunction it will be challenged. There has been an appeal. Obviously, this administration has shown that they will also try and get direct intervention from the Supreme Court. That has not happened at this point yet on this issue, but that does not mean that it will not potentially occur as these matters continue to develop. Now, what does that mean long term? Well, I mean, there were many RIF notices that had the effective date ultimately being set for this current week, from the 2nd, the 3rd, and the 4th of June. A lot of those RIFs that were issued to, particularly like the Department of Health and Human Services, many of those employees received their notices on 1 or 2 April and had effective dates 2, 3 June. So right now, to the extent that those agencies were covered under that decision, those have been temporarily prevented. That does not mean that they will not potentially still happen. And obviously, if they do, then some of these other opportunities for exploring your rights will, then ripen. Because if you have not been removed, you wouldn't generally, or have not been demoted, you generally would not then be appealing to the MSPB. There have been people who have sort of jumped the gun on appealing because it is a confusing process. People thought when they got their notices that they only had 30 days. For the most part, the MSPB has dismissed those without prejudice because they're untimely, they're not right. So in terms of, what does all of this mean in the grand scheme of things? A lot of the questions that people ask are not just about, like, obviously there's that, oh, how is this legal? How is that not? I mean, there's obviously a lot. I mean, agencies do have a lot of discretion when it comes to RIFs. Now, one of the big problems here is this really the agency? And that's one of the things that was addressed in this action in Northern California. Is this really agency action, since the agencies are being directed by the administration? And a lot of these things really haven't been done. There wasn't this long-term planning and definitions and development of these different, factors that they're supposed to do. So does that in and of itself create problems? It may. But, ultimately at the end of the day, does that mean that it can't happen at all? Well, that's what the injunctions are potentially trying to address. But in terms of you as the employee, you often are going to suffer the prejudice before you have the opportunity to really appeal. Now, I'm not going to say in every instance. We are helping a lot of people when they receive the notices to try and address things that may be clearly erroneous, or by virtue of looking at the documentation regarding how they've developed, like say the retention register, for an example, and looking at how they've defined the competitive area to potentially either get them to rescind or correct and reissue, or otherwise. And there has been some of that since the initial notifications back in April, in particular, for some of the HHS employees that we've assisted. Some of those employees actually have subsequently issued new notices, now not saying that their competitive area and now position is being removed, but instead saying, oh, you have now bump rights, and this is the position, this is your reasonable offer. So there are opportunities to try and make some challenges when you get the notice. You just can't do your official appeal until you face the actual unfavorable action. But in terms of, these large scale things, like if you've been in the federal employees retirement system and have at least 5 years of credible service, you're entitled to a pension, regardless of what happens here. That pension cannot be taken away from you unless you're terminated for illegal conduct. And even then, what that definition of illegal conduct is, pretty specific. Separation due to a RIF, reorganization, or even, a resignation doesn't negate your eligibility. It may affect whether or not you ultimately can collect now, but it doesn't mean that you lose that time. It's also worth noting that if you've contributed to a thrift savings plan for at least a year, you are fully vested in the agency's match. What you've contributed and what your agency has matched is yours. However, access to those funds may be limited depending on your age and how you separate from service. Now, when there have been a lot of other issues associated with, in contemplation of RIFs, like voluntary early retirement, the DRP, these things like VSIPs, voluntary separation incentives. Now, we don't really have time to get into them in detail, but also too, even if you did not take advantage of something like that, but you would have otherwise met the eligibility, say for a VERA, because you are 50 and have 20 years or more of service, or you have 25 years of service at any age, while you may not have taken advantage of a VERA, and you may ultimately not wind up being retained, you could still ultimately retire, but then under what they call a discontinued service retirement. And that has basically the same eligibility requirements for as VERAs, with the exception of if you are made a reasonable offer and you turn it down, then you're not going to be eligible for that. If you're not eligible for any of those things, again, you don't lose your time. You may not be able to draw your retirement right now. You may ultimately have to do a deferred retirement. But then severance does come into play if you are ultimately separated. But again, if you are made a reasonable offer, and this has come up quite frequently, actually, a person an example I was giving you before about someone we had been assisting who ultimately then originally had been notified that they were going to be separated as a result of a RIF, but then they got a new notice saying that, no, you're not going to be separated, you're going to be placed into this other position. Well, honestly, they were actually kind of disappointed because they had kind of wrapped their head around the idea that they were going to be removed and they were going to get severance. But now with that offer, which would be deemed a reasonable offer, it was an offer that was something that they are capable of doing. It is something that ultimately was, within the pay grade requirements. They now, if they turn that down, like, again, they don't have to accept it. And even accepting it doesn't mean that they necessarily wouldn't be able to appeal the fact that they're even being in that position to be, in that instance, because they were going to be demoted. But if they turn it down, they won't get severance. And that was, a shocking blow to them. But again, ultimately, the things that I think are best to prepare yourself for these circumstances before the RIF has actually occurred. Like, you have the notice, but you haven't been RIF'd. You want to examine the RIF notice to evaluate whether the information is correct, including the listed performance ratings, the service computation date, the type of employment, and any other issues that are in there. You're going to request a copy of the retention register to verify retention standing, because errors in the retention records can be challenged and corrected to ensure fair treatment. You're going to obtain a full personnel file to include your current position description. Position description, again, will be utilized to determine whether employees are placed in the correct competitive level. And also, this could even be somebody who has not faced a RIF notice yet. It is probably a good idea to make a request for your current position description, because if it is not in line with what you actually do, this would be a good time to try and make challenges to that and get that corrected. You're going to want to obtain a current copy of the organizational chart to help determine whether you're actually being placed in the correct competitive area. And you're obviously going to want to have a copy of all your previous performance evaluations to determine whether you're being correctly assigned retention standing and given your proper service credit. Well, we have a couple minutes left if anybody wants to shoot a question in there. Somebody asked about credit for my time credit for leave should my RIF length of service. I'm a little confused by the question. I think the core of the question is about how leave will be calculated. Generally, there is some, there can be some accreditation for leave, but we'd have to see the circumstances. We have some people who've already filed. They were separated and they've already filed. How does the injunction impact you? Well, the injunction, right now, the MSPB is obviously very overburdened. There's not a merits-based finding, so there's no reason for you to, like, at this point, take any steps to, like, drop your MSPB appeal. Because again, the challenges that are in the federal courts are being brought by labor unions. They're being brought by, like, attorneys general of different states. They're being brought by these representative groups. They may not ultimately have the same arguments that you would have. Also, they're not necessarily, we don't know, frankly, what's going to happen with those cases, because there have been some concerns about, whether or not some of these bodies actually have standing. So I would stand fast. You've done what you're supposed to do. You were separated. You filed timely. Now there might be at some point coming up some type of, you need to provide information to the MSPB. If you need help with that, that would be something you would want to talk directly to counsel about. There's some questions about transfer of function. Transfer of function is its own webinar, and that's why, unfortunately, I didn't really get into it, because we could spend probably 2 or 3 hours on transfer of function. I mean, some things like with chances, I mean, there's no ability to, people always like to know what odds and chances are. It's all going to be based on the what happened in your particular case, as to whether or not you're going to be entitled to certain damages, whether or not the RIF is going to be ultimately to be determined to be legal or not. But there's not really an ability to give odds, because we would be basing that off nothing, because we don't know what the specific challenge would be under your facts. Some people are asking, the California case is now at the Supreme Court, which was regarding the injunction, and when can we expect a response? When they feel like it, and much like most of the things in the government, I mean, they will tell the decision, but I mean, these ones tend to be relatively fast, because they are not the traditional types of where a person petitions for a writ of certiorari and goes up through this process. These will be relatively quickly decided, but still, what that means, there's no specific. But based on the time, unfortunately, I'm not sure. I know somebody just again asked about transfer of function. I don't have any specific timeline on when we're going to do this. But I do think that based on the fact of how many questions, it's something that we'll look at trying to plan a separate webinar on. But as I said, unfortunately, I have another consultation, so I'm going to have to get off here on the line, but I really want to thank you for attending today and all your great questions. As you can see from our slide, this is our information. Some of you may have some more specific issues related to, and even might want to have your RIF notification reviewed. Please feel free to reach back out to us. We certainly would love the opportunity to talk with you individually and answer your questions. But everyone, please have a great day. Stay safe, and I'm sorry that you're all going through all of this right now. Bye, everyone.